Hello, welcome back everybody. Nice to have you again as an audience. And I begin as always by telling you what it's all about today. Today we speak about the necessity and the role of the European Court of Justice in the system of European Union law. And you will need that as basics to understand why and how the European Court of Justice can have an influence on the yeah, um, interpretation and application of EU law for taxation. So to make clear where we are, here is subchapter 5 of the first basics chapter of our lecture. Good. So just to remind you of what I told you at the end of the last video, if in the European Union you have the plan to create uniform laws for certain aspects in the one or other way, either by a regulation which then constitutes a single uniform valid text throughout Europe, or by harmonizing the contents of some details of other laws just by ordering to give them the same contents throughout Europe by a directive. If you do that, the whole idea is absolutely senseless if you do not take care that this uniform rule is afterwards also applied in a uniform way, and for that purpose it must be safeguarded that all people interpret that rule in the same way. Now that is probably unachievable under normal circumstances because you know perhaps that proverb, two lawyers, that means three opinions. And for this reason, you need to give some authority, or you need to create some body or institution which gets the right or the monopoly even to decide in a binding way for everybody what's the correct interpretation of the rules in question. Otherwise, the whole system can't work. And for this reason, the European Court of Justice has been appointed, has been instituted within the treaties of the or on the European Union already since the very beginning of the whole European project. So it has a fundamental rule, fundamental importance, sorry. And so it is very necessary to have a look on the rules governing that and to know about the function of the European Court of Justice. First, in today's Article 13 of the Treaty on the European Union, you have a list of the Union's institutions, and there is also the Court of Justice mentioned. So that's nothing special. Article 14 and the fourth following then just explain the basics about these institutions, and Article 19 Treaty on the European Union says the Court of Justice of the European Union shall include the Court of Justice, the General Court, and specialized courts. It shall ensure that the interpretation of application of the treaty, that there the law is observed. Member states shall provide remedies, legal remedies, sufficient to ensure effective legal protection in the fields covered by union law, so that you can always go to court if union law is applied. And the Court of Justice shall consist of one judge per member state, and it shall be assisted by advocates general. And then the General Court shall also at least have one judge per member state. There are more people there. And the judges and the advocates general shall be chosen from persons whose independence is beyond doubt and who satisfy the conditions set out in some articles, and so on, and they shall be appointed by common accord of the governments of the member states, and so on. And then they say the Court of Justice shall rule on actions brought by a member state. give preliminary rulings. We will later concentrate on what that is and why it's important, and rule in other cases provided for in the treaties. So that's roughly an overview about what the European Court of Justice has to do. The details are then laid out in the articles of the Treaty of the Functioning of the European Union. Now, the first question is naturally, if we look to the structure of that court, why is there one judge from each member state? Well, all the member states should have equal rights. You know, the EU is an association of states, and states always take great care that they have equal rights. And in practice, this system also makes sure that the knowledge about the legal system of each member state and the ability to work yourself into the matter, how it is regulated at the moment in a certain member state, that this expertise is available everywhere and for every country in this within the European Court of Justice. And you leave no country without representation. So each country can have the feeling that these are not foreign judges, but these are judges where they are represented. Now, the seat of the European Court of Justice is Luxembourg. That has been decided because when the European Union was first founded in form of the European Community, European Economic Community in the 1950s, then this was a kind of a federation of 6 original member states. And in a federation, it's customary that institutions of that federation are not concentrated on one single place, but that in order to underline that all states have comparable rights, then the major institutions are usually equally distributed among the member states, and so the ECJ was for Luxembourg. Well, a very important thing is you shall never mix up the European Court of Justice, so the Court of the European Union, with a totally different court, which is named similarly, the European Court of Human Rights, the ECHR. That is a court which is located in Strasbourg in France, and this is the court which belongs to the Council of Europe. And the Council of Europe, remember that, is an organization of approximately 50 member states, mostly European, which has nothing to do at all with the EU. It was founded at the end of the 1940s. It is a strictly interstate organization, a classical international organization, and it is, for example, the author of the European Convention of Human Rights, but has nothing at all to do with the European Union. You should keep that in mind, because especially journalists are really keen on mixing the two institutions up. For example, very often you find articles in newspapers where somebody talks about jurisdiction of the European Court of Justice, and then comments that in a way that you get the impression, oh, the journalist thinks that they are talking about the ECHR, or the other way around, that a jurisdiction of the ECHR is mentioned, and then the EU is criticized for having such views and leading to such consequences, that the own government is judged for or judged against because of a violation of human rights, and that this is a scandal and this is a negative impact of the EU. Please memorize that these two institutions have nothing to do with each other. So our topic is only the European Union Court, the ECJ. Now, the Article 19, which I mentioned, already mentioned that the European Court of Justice is, when you take a closer look, set up are made up by several parts, several different institutions. Originally, there was really only the European Court of Justice. Now, when the EU got larger and larger, involving more and more member states, more and more cases came up to the ECJ, so one had to relieve the ECJ of some of the burden without cutting back the legal protection. And so the solution was that a few types of cases were transferred to lower European courts, which were especially founded to take over these cases which have not such a general impact. In principle, one has to distinguish between the European Court of Justice in the stricter sense, that is, that gremium which consists of one judge per member state and is the highest European Union court, and the lower courts of the EU, which can be established by consensus between the member states and the European institutions according to I do know which rules. And these lower European courts are also a part of the European Court of Justice, if you speak of it in the wider sense. So if the treaty says a case has to be going to the European Court of Justice, you have then to find out, according to the special rules on the organization of the European jurisdiction, if that case goes to the lower court or the ECJ in its stricter sense. And especially these courts take over cases where individual cases have to be decided. So, for example, where not only the law has to be interpreted, but where there is also fact-finding work and where you decide a single case. For example, you know that if the European Union made a decision, for example, a certain enterprise in, let's say, Germany is ordered to pay back an illegal state subsidy, a state aid, which is forbidden to the German state or so. Then this decision is made by the European Union Commission, and it's legally binding as an administrative act. You have to follow it. It's the order of an authority which can give you commands. And now the system of the treaty says an act of the European Union cannot be overruled or put aside by a court of the member states, because that would give the member states the possibility to get rid of orders of the EU just arbitrarily. So it has been decided that against such a decision of EU law, you can only get legal protection from the European Union Court. And now, as you are a single case, as facts and files have to be dealt with, as it's a mass of investigation probably necessary to decide such a case, such a case is then presented to one of the lower courts. In our case with the state aid, probably to the general court. Also, what is also a frequent thing is the European Union employs some officials. By the way, the complete European Union has been said to employ less officials for the administration of the whole European Union than the city of Cologne. This is probably true. But imagine if they have some 10 or 20,000 officials employed for the administration of Europe. There will be always cases where such an employee quarrels with its employer, the EU, over payment issues, working conditions issues, and other stuff. And now again, the principle is one did not want to give any member state institution power over an EU, over the EU. And so basically these EU officials can only address their cases to the European Court of Justice. Now the European Court of Justice Europe's highest judges, so the 27 guys in the stricter sense, are not really interested in deciding of if a certain official really is entitled to an increase in a pension or an increase in salary or not. And so naturally, that also has been outsourced to a specialized lower court. Because in the origin of the EU, that was yet still decided by the European Court of Justice itself when these cases grew more and more, and when the capacity of the higher judges was filled up more and more with more important cases. Then they wanted to outsource these other things to a lower European law institution that was then a specialized court on the affairs concerning the employees, the functionaries. So when you ever come across a court decision of the European Union, when some case first had to appear in the general court, then you will have a file number beginning with a T, because the general court in the French version is called the tribunal. When you have the other court, which deals with the complaints of the employees, the file number begins with an F for functionaries. And if you have a case which directly goes to the European Court of Justice in the stricter sense, it begins with a C for curia or court. So you can distinguish which part of the European Court of Justice deals with which matter. Now the lower courts, they just apply European Union law to a concrete case, and it might be that one has to make sure that there are no contradictions in their jurisdiction. So when somebody thinks, one of the parties involved, that the laws of the EU rules have been wrongly applied there, then you can ask the ECJ for a legal review. That means the higher court, the European Court of Justice, will only take a look if the EU law has been correctly understood and applied. They will not bother again with the finding and the checking of the facts. So they will just accept the report of the lower court, what has happened in the case, and they just look through if there is any misunderstanding concerning the contents of the legal rules. That makes sure that, again, that the legal rules are always correctly understood and decided just by the ECJ in the stricter sense, so that we have a uniform jurisdiction on all understanding of the law still everywhere in the EU, because that comes still from the same head. Well, now what you also will come across is that there are strange people in the surroundings of the ECJ, but they are not really strange, only their name is a bit strange. What I want to ask you, or what I'm aiming at, is the question, what is an advocate general? And the answer is, well, it's kind of an independent expert or official employed by the EU who does research into the matter, the legal questions especially, and in the end delivers a professional opinion on the case to the court, which is a kind of proposal how the judges might do their judgment. The idea is, I believe, taken over from the French legal system. You know, for example, in Germany, when there is a criminal prosecution, there is, apart from the parties involved, also somebody who acts for the state as a state prosecutor. So there the state has its own advocate, which brings forward the opinion of the state on the case. And in the French legal system, I suppose that this institution also exists in other kind of legal proceedings, and that is probably the origin of that institution, that here we have acting for the EU a kind of a lawyer or an advocate presenting his assessment of the case to the judges. Now, the Advocate General gives his or her opinion publicly. That opinion is usually published on the internet site of the European Union Court. And very often the judges then follow the proposed solution of the Advocate General fully, or at least in part. So when the opinion of the Advocate General is published, you have usually an idea how the final judgment might look like. It's highly probable that the judges will not completely decide against that opinion because, well, these guys are experts. So it's very, very informative to read these opinions because they give a hint to which decisions can be expected. Now, naturally, you have to see they are not decisions. What really later counts is the final judgment. The opinion of the Advocate General is nothing which is legally binding. Now, that is something which also has the one or other advantages, because such an Advocate General can be far more courageous in expressing opinions on what he or she regards as adequate than the judges. The judges know whatever they write has legal consequences and is directly considered as confirmed and given. Now, such an Advocate General can also make the one or other suggestion how things should be interpreted in the future, which is a bit new and a kind of a test. How will the public react? So it's also if you are interested in developments in the long run, it's also interesting to read the opinions of the Advocates Generals, because there you can see which new ideas are on the way and make their way to the European Court of Justice. Usually new opinions start there, and after some years they are probably taken over by the judges or they are dismissed. So it can be highly informative to compare the opinions with the final judgment. For example, you can ask yourself, where did the court follow the ideas of the Advocate General? Where not? If the Advocate General proposed something and the courts abstained from taking it over, what does that then mean? For example, did the court clearly position itself against this idea? Or did they just remain silent and solve the case identically, but with other reasons, so that they didn't want to take over the theory of the Advocate General why something should be done? Very often, for example, that happens if an Advocate General has very progressive ideas. First, the judges try to avoid touching that wasp's nest. But it might be that they do not dismiss the idea, they just let it uncommented, so that literature and experts can begin a discussion about it. And it might be that years later people say, yeah, more and more a consent forms itself that this idea to understand EU law might be correct. Or on the other hand, it might be that the court really makes a statement on the idea of the Advocate General and dismisses it, or that they take over an argument. So in that case, it can really be interesting to read these opinions in order to get a feeling for future developments. Might even be that if an Advocate General proposed a new idea and the courts remained silent, you see, okay, they didn't find a majority to reject it. They didn't find a majority to say, yes, this is already what we believe. Then they remained silent. Might also be that they officially reject the argument, although the Advocate General was in favor, then you know, okay, they are rather positioned against it, and so on. So that's highly interesting, but not legally binding. The judgments of the court are instead legally binding. So it's important that you are able to read them. Now the natural situation is, if the ECJ is asked to decide if a certain behavior of a member state, for example, is in compliance with EU law, then, well, you must imagine the situation of these people there in Luxembourg. They know that most people outside in the world do not know the EU rules which are in play. And they also know that the average law expert outside there in the member states doesn't know which rules in France or so, or in Germany, the case is about, if these rules are in conflict with EU law. So also that all these people do not know what happened in the case. So the first thing which the court decision will do is they describe which court asked them for an answer. Then they will begin to quote from the rules in question. So this case is about the correct interpretation of the following EU rules, and then they quote it and explain them. And then they also describe which national rules come into play when it comes to decide over the case. So that somebody who is not familiar with the legal framework can get an overview about what the whole case is all about. Otherwise, you would not be able to understand the whole thing. So then they also describe some details of the case which are relevant for the decision. So you also get the names of somebody who complained, what it's all about, and so. And only afterwards, then they begin to talk about the legal situation. So there you will usually find some important aspects which are not always to be found in a national court decision. In a, let's say, German national court decision, you have things like the court decision describes what the case is about, they describe what happened, they describe what the one party brought forward as arguments, and they describe what the other party brought forward as an argument. Then they ignore both of them and they develop an own opinion from the beginning to the end. That's the correct application of the law. Now, when it comes to the ECJ style, there you find that an argument or a view which one of the parties involved in the court case has brought forward will nearly always be commented explicitly by the court. So the court says, let's say France brings forward the following idea, or the following argument, or the following view. Then one or two sentences follow which say, the court says, well, this argument could only convince if, or this argument cannot convince because. So they commend every important argument which the parties brought forward. And then later they develop their opinion relatively short, in a relatively short way, but based on what they have argued before, on which arguments they have rejected and which they have accepted. The important thing is here you get a clear feedback on the arguments which the people brought. So you can clearly think what the court thinks about the value of a specific argument or argumentation. And that allows you to draw conclusions for further cases. For example, when you see another question showing up in your mind where that argument could also be used in favor or against the legality of that behavior of a member state or of a state authority or of a taxpayer, then you know already what the court thinks about that argument. Can it be accepted or not? Now, naturally, it can be that the view of a court varies a bit. But it might be that, for example, in the first decision, they accept a certain argument, and later they find out, okay, it doesn't convince us really. But you can observe the court cases over time. And now, when you see that a specific argument has been brought forward several times and has always been several times been commented in the same way. For example, it has always been rejected with the same reason. Then you can reasonably assume that this is now a standing jurisdiction of the court, that now the court always will have that view on the value of that argument. And if you can't bring convincing reasons why this comment is then to be rejected, if you can't convince them to change that view, you can say this jurisdiction will stand in the future too. So here you can predict from the lecture of the argumentation which view the court will hold in future cases, and that certain arguments have no value or will be convincing. Bring a chance for you. So that makes reading such court cases so valuable for experts in law or in taxation or in other aspects. So you will probably not be mainly interested in the case which happened somewhere in France or in Spain, but you will read about the legal rules and say, there's an argument which they brought forward, and that argument also is familiar to me from taxation, from debates over tax laws in Germany. And here I get now the feedback that in that circumstances here, the court rejected the argument as unconvincing. Oh, highly fascinating. That would mean that in my context, the argument would probably also be dismissed. Wow, interesting one. Would that mean that there is a certain legal uncertainty now, or that a rule which I always regarded as clear now becomes questionable? Highly interesting. So you could draw parallels. Then, if there are arguments, how did the court comment on them? They usually give very short, precise, and sometimes brutal comments. For example, I remember a court decision or two court decisions from the 1990s where fiscal officers brought forward that their behavior was justified. I don't know what, for which reasons. And the answer, and it was a question, for example, if I remember correctly, if the taxpayer could claim damages also. And one thing was very, very nice. There was one statement where the court says, if the fiscal office here violated EU law in a qualified way, that's a question of fact finding, and the facts have to be determined by a local court. And then there came the nice statement, but during its assessment of what happened, the local court will have to ask itself if the behavior of the fiscal authorities can still be called reasonable. This is depending on in which language version you read that. This is rather a brutal criticism. In English legal usage, okay, it's not so hard as in the German translation. In the German translation, one might get the impression that the court suggests that the local court has to ask itself if the fiscal authorities can still be regarded as mentally okay. By the way, that was in all probability not intended in such a harsh way, but you can at least sometimes obtain a very, very clear comment. And naturally, if you met an argument several times in the same way, you can conclude this is going to be permanent jurisdiction in the future. And that makes reading court cases so interesting. Now, and by the way, from that you can sometimes prognosticate. If you read the argumentation of the other side in a debate before court, you can sometimes say, okay, everything which my opponent has brought forward now shouldn't worry us, because all these arguments are already doomed. They just ignore the standing jurisdiction, and probably the self-respect of the judges will not allow that without any compelling reason they reject everything which they always permanently said before. So the interesting thing is then also, if you go to court and you exchange your opinions before the court case really begins, that it's then interesting if the other side brings forward new arguments, or if all the arguments brought forward are already such ones which have always been rejected by the court. Then you have good chances to win. Okay, now which cases are possible before the ECJ? Several types of cases can go to the ECJ. The most important ones for us in taxation are first cases where the European Court of Justice has to decide if a member state of the EU has violated its obligations which it has under the treaty. Now, a violation of the obligation can be everything, so even the unwillingness to follow a very, very small detail of a directive can be an infringement of the treaty obligations. So it can end up in a court case where the member state is, judged against, or where there is a judgment made, the member state violated or infringed its obligations under the EU law. Now, you and me, we are not allowed to start such a proceeding, such a lawsuit against a member state. That can, under the treaty, only be done by the Commission and another member state. That one member state starts court proceedings against another member state is, however, generally regarded as not very polite. It is not very diplomatic. So the member states usually knock on the door of the Commission and leave the job to the Commission and say, well, dear Commission, what about starting court proceedings, a case in the ECJ against this member state, because what they did was not correct under the treaty. It might be then that during the time when the case is held before the ECJ, every government has the right to give an opinion during or to plead, to make suggestions during the court proceedings. And so it might be that then the member states bring forward or take part in the court case with an own lawyer, which then expresses support and additional arguments for the position of the EU Commission. But the job to start a court case against the member state is usually very often left to the Commission. Now, the Commission is not obliged to start a court case for every infringement of the EU treaties or EU law. It has a political discretion if that is recommendable and if it was the while and the effort. They can also try to negotiate and find a compromise with the member states, so that the member states gives in voluntarily and begins to comply with the treaty obligations. Or they might say we have other business to do. So they can freely decide if they start a court case or no. So you can't start it. What you can do is you can write a letter to the EU Commission where you inform them about certain things or events which you think are an infringement of EU law. so that they can form an opinion if it's worth starting proceedings because of an infringement of EU law. The advantage is if you go to the Commission and give them a hint, there is, I believe, a violation of some treaty obligation. For example, a directive is not correctly followed by some state institution in member state A. Then that brings along no costs for you, and that is very, very convenient. On the other hand, you are not involved in the case, so you can't take a direct influence, but you can motivate the Commission to start it. Everybody has that right. Well, let's go on. The other important type of cases where the European Court of Justice is involved is the so-called preliminary ruling. For this, you need to know some background. Usually, there are cases before national courts where EU law can play a role. For example, when a national authority and not an EU authority ordered something by administrative act, you can always file an objection against that. They have to rethink over it, and if they still reject your objection, you can appeal to a court and start a lawsuit against them or a complaint against them in court. Now, the court has to decide based on the law, and the law includes not only national law but also European Union law. So now a national court has to decide on grounds of EU law, probably. Now, where EU law is applicable, one has to prevent that everyone does with EU law what they want. We want to secure a uniform interpretation. So in that case, the national court in question has to apply EU law, but we must prevent that the interpretations diverge. And that can only be done in a way that you give the authority to interpret EU law to the European Court of Justice again. So in these cases, there has been established a procedure that a national court can, or sometimes must, ask the European Court of Justice for the correct interpretation of European Union law. And then after they got the answer of the ECJ, how EU law has to be interpreted under the aspects in question, then the national court can apply the answer to the case and decide the case. That is called the preliminary ruling or preliminary ruling procedure, because the final decision on the case is made by the national court because it's its case, but the question how EU law has to be interpreted is decided beforehand by the European Court of Justice. That is, beforehand, is preliminary, and a ruling is a decision or a general information how something has to be understood. So this is a very efficient way to share the work. Imagine you complain about a tax notice from the fiscal office in Cologne, and your argument is it violates a certain detail of an EU directive which nobody really knows about. Now the fiscal court in Cologne will then have to take the case. They will investigate in all the facts. They will find out what happened if you objected in due time. They will care with all these fact-finding issues and all the relevant national law. And when they later come to the conclusion, well, the case decision really relies on how EU law has to be interpreted here, then they say that's not what we have to decide. Now we ask the European Court of Justice to rule on that specific matter, and when we get its answer, then we know what to do, then we know the full meaning of the legal rules, can just apply them to the case, decide it, and the matter is closed. So the ECJ can concentrate itself on the things where it really is expert and where it is needed. They don't have to care about the fiscal laws of Germany. They wouldn't know them. So they couldn't decide the concrete matters. They can only decide about the interpretation of EU law. Only for that you need them. So the court in question just says, we have this and this specific question. They describe the circumstances, everything which is needed to decide about the correct interpretation, pass it on to the ECJ and ask for an answer. And that answer is then binding. So you and I will never be able to start a court case against the member state, number one. But every one of us will be able to go to a national court to complain against the decision of this authority. And if our argumentation fundamentally then relies on a certain EU rule, then the national court will probably shift on the case to the European Court of Justice with the question, how is, under such circumstances as here, that EU rule which the plaintiff brings forward to be correctly understood? Now, it's clear that these preliminary rulings are in practice the most relevant court decisions for tax matters, because every tax advisor or every taxpayer can go to the fiscal court somewhere and can argue based on EU rules if that argumentation is not complete nonsense, so that the court begins to think, okay, might be that that person is right. And if so, then our decision is dependent on how EU law has to be understood. So we have to ask the European Court of Justice now. That is something which every single taxpayer can do, can start. You cannot force the court to ask, but you can suggest it. And this is the way how most cases arrive at the level of the European Union courts. A preliminary ruling will always end up directly in the hands of the European Court of Justice in the strictest sense, so of the court with the highest judges, because here it's a matter of uniform interpretation of EU law, and that always is a case for the highest judges. This is very often the case. The Commission itself is not so keen on attacking the member states with regard to tax law, because this is something which the member states rather don't like. The Commission probably fears some political damages if they bring up new ideas. But if some taxpayer does it and succeeds with that in court, then the Commission can say, oh, it's not our idea, but now when we know how EU law has to be applied to tax matters too, then we naturally, it's our job to safeguard the correct application of EU law. So now we can follow it up and tell other member states, hey, you still ignore the interpretation of EU law with regard to a certain tax problem which the court has given 2 years ago. That's not okay. And then they can start a case because of infringement of treaty obligations. But then it's no longer so impolite and doesn't create any political or such political damage anymore, because then it's already clear for the member states, okay, we have to oblige some obligation there. So here the Commission very often leaves the initiative to the taxpayers. Now you have probably heard, if you ever got educated in law matters in a more deeper sense, that usually a court decision is only something which is binding for the two parties involved. Naturally, others couldn't defend themselves in court, or a court decision which orders me to pay a certain amount to an employee, well, that has nothing to do, no direct effect for Mr. Smith or Mr. Miller, other employers. They also have a right, if something doesn't convince them, to go to court and complain there, bring forward their arguments, and to lose and to win. But now the thing is that a preliminary ruling is not a court decision of a case. A preliminary ruling is the official question to the European Court of Justice how EU law has to be correctly interpreted. Now, the interpretation of a legal rule cannot be different according to the case. You can't say a certain rule means this and this if the plaintiff is Mr. Miller, but the rule has a completely different sense if now Mrs. Smith comes up in court. That is impossible. And this would also not comply with the sense of the whole procedure. The idea is the court has to make sure that European Union law is always interpreted in an identical way throughout the European Union. So what is required from them is a statement which clarifies the understanding of the rule in question in general. So clarifying the correct interpretation for everybody. This is also the reason why a member state who was not party of a preliminary ruling or who only took part by a lawyer who uttered some opinions later is nevertheless bound by the interpretation which the court found during the procedure, because what the court found in the preliminary ruling is a generally valid and generally applicable interpretation of the rule in question. You can even, if you closely watch the final lines of the decision, usually printed in bold type, the so-called tenor, that is the thing which is officially the decision. That decision is usually expressed in a way that it covers or that it has a general meaning. You will not find a thing like paragraph 8a KStG in Germany is forbidden by the freedom of establishment. The tenor will be the freedom of establishment has to be interpreted in a way that a rule like Germany's 8a KStG is forbidden. So it's always, even if they speak about the compatibility of their rules with the national rule, that they are always insist on this is a general statement, not 8a KStG doesn't comply with freedom of establishment. By the way, that was a rule which was a court decision which came in 1994. Today's paragraph 8a KStG is something completely different. But there you could read not this single rule doesn't comply, but every rule which is alike doesn't comply. Or they sometimes make a rule which a decision which very much is concentrated on an individual case, but then the tenor is still EU law forbids a member state to act in cases like the one presented to us in the following way. So what they always insist in is that a preliminary ruling is a generally applicable clarification of the contents of EU law. That means after there is a preliminary ruling, every state authority throughout the EU knows how such rules have to be interpreted. They are all bound by the by the rule of law to follow during their application of law to cases, to follow that clarification brought forward by the ECJ. And so nobody can deviate. There is already since the 1970s or 80s a standing jurisdiction. If a national authority thinks that an interpretation which the ECJ gave to an EU rule was wrong, they have no right to deviate. The only way how deviation can be made is that if there is a court case and the court asks the European Union in another preliminary ruling if the ECJ is willing to change its opinion of the matter, which usually will not happen. So, yeah, here we have the rules in Article 267 Formally, that had the number 234, and initially, in the first version of the treaty, it was 177, so the numbering has been changed several times, but the contents was always similar. The Court of Justice of the EU shall have jurisdiction to give preliminary rulings concerning the interpretation of the treaties and the validity and interpretation of all acts of the institutions, bodies, offices, or agencies of the Union. So everything which is EU law can only be interpreted by the ECJ. Where such a question is raised before any court or tribunal or of a member state, that court or tribunal may, if it considers that a decision on the question is necessary to enable it to give judgment, request the court to give ruling thereon. And where such decision, 267, paragraph 3, where such a question is raised in a case pending before a court, against whose decisions there is no judicial remedy under national law anymore. So where a court of last instance is dealing with a case, where you can't have any juridical review afterwards regularly again, that court or tribunal shall, that means must, bring the matter before the ECJ. Okay, if such a question is raised in a criminal case, the Court of Justice shall react quickly, because it's clear if it's a matter of freedom or imprisonment, you can't wait for 3 years before you get an answer. Okay, now when you look to these rules, you must distinguish two cases. First, every national court, the lower and the higher ones, can start a preliminary ruling and ask for a decision of the ECJ if it regards the answer as necessary for the case decision. Paragraph 2, 267. And every national court of last instance must start a preliminary ruling if EU law is relevant for the decision. Paragraph 3. Now, a court of last instance is the one after the matter is closed, where there is no review possible afterwards. If you have a higher regular instance to which you can appeal, it's still a case of paragraph 2, lower court. If it's the highest court in the sequence, then they have to start the preliminary ruling. This brings along a first important conclusion. It is never possible that a court of last instance, for example, like the Bundesfinanzhof, the Federal Fiscal Court, can ever utter a view on the interpretation of European Union law which has any binding effect or any real value. Because if a statement is made by a national court of last instance on EU law, that is either something which is a complete repetition of things which have already been always said by the ECJ, so that they are clear, and you don't need that BFH decision on the matter, or it's a kind of usurpation of the ECJ's privilege to interpret the EU law in all cases, where a court of national last instance has to decide a case. Because if, let's say, the Federal Fiscal Court, Bundesfinanzhof, ever decides on its own, based on a view on European Union law, which is not yet, let's call it, certified by the European Union Court, this is a violation of its duty to refer the case for a preliminary ruling. Whenever their opinion is not absolutely self-evident, they infringe the rights of the ECJ to decide on the interpretation. And so there can be never any BFH or other higher court rule which says something of interest. You can only get the correct interpretation of EU law from ECJ decisions. This is not known, has not always been known to all courts of high instance. Sometimes it might be, judges are human beings. It might be that courts might be a bit unwilling to involve the ECJ into court. How can we avoid this? This has, for political reasons, for example, this has often brought up the question under which circumstances it can be legal and tolerated that the National Court of Last Instance may not give a case to the ECJ. First, the current view is that Article 267(2), the rule for the lower courts, allows the lower courts to refer a case. So the measures, the requirements are perhaps not so strict. But the first thing which you must read there is it depends on if a question is raised concerning EU law. That means, and the decision must depend on it. If the interpretation of EU law does not pose a question, then the National Court does not need to ask for a preliminary ruling. Then they can apply the EU rules as they are known. On the other hand, wherever there is a question, so where EU law's interpretation is open, the court can, and in case where it is a last instance, must ask the ECJ for its interpretation. Now that raised the question historically, under which circumstances is a question an open question. So there the ECJ said, because what is a question in the sense of 267 is already a question how the treaty has to be understood correctly. So the ECJ was bound to answer on that and nobody else. The ECJ said, okay, there are two situations where we can imagine that something is not a question, where EU role comes into play. First, we have already decided on the correct interpretation, and that interpretation fits to that case. So it's not a similar case. Everything has already been made, which you need by our decisions. Or, other alternative, the EU rule is absolutely clear, so clear that we do not need to get asked. Now, this was always a kind of a loophole where national judges try to escape through. They always said, this is clear. Now, so the court had also to say when is a question clear in the sense of 267. So that it's no longer a question, but a given fact, a clear fact. And the answer is, a question is only clear if not only the members of this court are convinced to know the right interpretation, but that they are also convinced that every judge throughout the whole European Union will share their opinion and every competent legal expert. Now, this is rather a theoretical case. Imagine thousands of judges and law experts. Can you really imagine that you assemble 10,000 law experts in a room and then stand in front of them and tell them, hey, I have an opinion on the law and this opinion is clear to everybody and nobody can convincingly debate it? Then you probably end up in the hands of a competent doctor in an asylum, I believe it's pronounced, in an asylum for the mentally ill. You can nowadays not get the conviction, the honest conviction, that every competent law expert throughout the EU shares your opinion. Otherwise, you are on the verge of madness or probably beyond. Historically, there have been some very awkward examples where a high court tried to generate or to get this conviction. For example, I remember one court decision of the Fifth Senate, so the Fifth Chamber of the BFH, where they decided that a certain thing did not need to get referred to the ECJ for a preliminary ruling, on the grounds that the matter was totally clear, and all the court decisions which they cited in support of that it was totally clear were court decisions of former times of the Fifth Chamber of the BFH. So to convince yourself that nobody else apart from you could ever or that nobody else throughout the world could have a deviating view, deviating from yours, and then only bringing forward your own former statements is really a very awkward approach to a situation. Well, that is 20 or 30 years ago, so not the present state of affairs anymore, at least I hope so. But sometimes judges try to do such tricks. Yeah, you can say if it's not evident rubbish, then the matter is open, or well, if things have been already decided. Especially my personal view would be if you find opinions of the Advocate General where an argument shows up which has not been officially contradicted by the court. One could say, okay, this is already a serious opinion and must be taken serious. In that case, nobody can ever bring forward convincingly if the deciding judge knows about that this view exists and has not been commented by the court, then the court can no longer get the conviction that the matter is clear. Or if you know about court decisions in another member state where a certain view has been held, the matter is no longer clear, or similar things. It might be important to motivate judges by pointing out these requirements and to prove to them that the view which you hold has been held by other judges somewhere, so that the matter is not sufficiently clear so that the ECJ should be involved. Good. The next thing is naturally, as 267 said, the question must be necessary for the decision. So if the national court says we can decide about the case without taking that EU rule into consideration at all, then they don't need to refer to the court. For example, if you started a case in court against a tax notice or a tax assessment by the fiscal office, and then you argued with EU law, and then the court finds out your objection was filed after the end of the objection period, then they can say, okay, we are sorry, but due to the procedural law rules, the whole case is already gone and died because you were too late. So in that case, your whole argumentation about the contents of EU rules and their implications for your tax notice are completely unnecessary for the decision of the court. You were too late. We are sorry. The EU rule does not need to be interpreted to give that answer. This is in all probability also the explanation why a lower court is not always bound to present a case to the court, because it may be that a lower court says, okay, we might imagine that depending on how you interpret certain other rules of national law or other things in the case, it might be that the case will later be, by the higher instance, be solved on grounds of rules which have nothing to do with EU law. So we spare the ECJ the work and just allow the taxpayer to have the case reviewed by the higher court. And then if the higher court says, okay, EU law can't be avoided during the decision, then they have to pass it on. That might explain that system here. So any national court may bring a matter to the ECJ to obtain a preliminary ruling. There have also been disputes about if that right can be limited. For example, very often you have procedural law which says a case begins, let's say, in a lower fiscal court. Then fiscal court makes a judgment, and then you go and have it reviewed by the higher court, the BFH, for example. Now the BFH says a certain rule has been wrongly applied and then hands back the case for a renewed decision by the lower court. You were wrong in your understanding of the legal rules. Please do the work again. Now you are wiser. That happens. And to make that, to avoid a ping pong effect, BFH says you shall apply the law in a certain way. We say we don't. In that case, the lower court is usually bound to apply everything which the higher court has already decided. They can only look for some missing facts or so in order to be able to apply rules whose relevance have been detected just recently, and so on, and then to finish the case. Now the question have come up, if imagine BFH has ruled and, for example, has completely ignored the relevance of EU law because that question only came up later. Is then the lower court still entitled to refer the case to the ECJ, even if that ends up when deviating from the BFH decision? And the answer of the ECJ has always been yes. Article 267 says a lower court can ask for a preliminary ruling. Article 67(2) does not have any time limit for that right. A member state is not allowed to cut back or cut away a right which 267(2) of the treaty gives to a court. Sometimes it is regarded as allowed implicitly by a treaty that a member state makes some restrictions which are necessary so that the world doesn't break down. But this is not accepted in this case. Here the court always has held, well, there is can be no reasonable reason for cutting back the right, limiting the right of a lower court to ask us, because if a higher court has interpreted ECJ rules wrongly, it cannot serve the correct application of the law to bind the lower court to apply law wrongly. If the higher court has completely overlooked the relevance of EU law, it can also not serve the purpose of jurisdiction to decide correctly, to forbid the lower court to ask us and make a correct decision. So it is clearly written in the law, a lower court can, and that means can always, refer to us, the ECJ, and there can be, or there is not a reasonable argument why this privilege could be restricted. The only situation when a lower court can no longer ask is when they have already made a judgment, because then the judgment is made and then it's clear you can't, after you decide it, you can't ask again, because then the question must be necessary for your decision. But before the decision is made, you can always interrupt the legal procedures and ask the ECJ. Yeah. So that is something which also not everybody knows. What if not a court but the national authority is faced with a question how EU law has to be understood? The Article 267 of the Treaty on the Functioning of the EU says clearly that a court can ask for a preliminary ruling. So the ECJ says always an authority, a state authority, has no right to ask us. Would be too much. As always, a state authority has to apply the law. That's their official duty. And they have to interpret that on their own, according to their best knowledge, in good faith. That's clear. So they can't, for example, say we deny the applicability of EU law and wait for a court decision until a taxpayer or a citizen complains and goes to court. They have to apply it on their own, according to the best potential interpretation, even if that is in favor of the taxpayer. And if a citizen then doesn't agree with that interpretation, you can still apply and appeal to a court. Also, if you see they are unwilling to apply EU rules, or they have an interpretation which does not convince, you can also go and make a complaint to the European Union Commission with the intention to motivate them to start a case because of infringement of treaty obligations. Now, what if a national court fails to ask for a preliminary ruling? This is now the last question for today. Well, the state is obliged to follow the treaty. The state is made up by parliament, judicative powers, and the executive. Now, if the courts, so this pillar of the three pillars of the state, doesn't comply with its obligations, this is a breach of the treaty obligations of the state. So the state can be held responsible for that. So the EU Commission could accuse a member state of infringement of the treaty if one of its higher courts doesn't comply with the obligation to refer a court to the ECJ. That is usually not done because it's rather regarded as impolite by the courts. They don't like to be criticized. However, I believe there is the idea discussed at the moment, at least in the EU Commission, to bring Germany before the court, because the German Constitutional Court decided to write something which stated that certain EU rules were wrongly interpreted by the ECJ or such things, and were not binding. This would be clearly an infringement of the treaty. Furthermore, if you, as a higher court, do not ask the ECJ for a preliminary ruling, such an infringement of the treaty obligations could entitle the people who suffer damages from that behavior. They would be entitled to sue that state for damages if the violation is qualified enough. Qualified is, roughly explained, clear and unexcusable enough. So if one can say objectively that was a clear violation of the obligation to ask for a preliminary ruling at that time, it might entitle you to financial damage claims against that member state. And the member state could even be punished in case of constant unwillingness to follow the court jurisdiction by punishment payments. They could go up to millions per day. Where a lower court didn't ask for a preliminary ruling, it's more difficult to criticize them because under the treaty they have an option to ask and not a duty. However, from the principle from the rule of law, one has to expect that a lower court exercises such an option in a reasonable way, not in an arbitrary way. If it ever came up that a lower court says we do not ask the ECJ because we are unwilling to do so, or because it's Thursday today, or because we just don't like your face, then one would have to ask the ECJ, how is the word a lower court can ask to be interpreted here? Is that an option which is completely free and arbitrary, or is that meant as an option which you have to exercise on the basis of reasonable grounds, reasonable arguments? Then my personal expectation will be that if the court is ever asked such a thing, the court will answer that naturally the rule of law requires that a judgment of a court is never made, or the behavior of a court can never be arbitrary. Well, so that can means can on reasonable grounds ask or not. However, there has been also some 20 or 30 years ago a case where somebody appealed to the BFH on the grounds that the lower court didn't refer a matter to the ECJ. And the BFH then said, that's not a question to criticize the decision of the lower court, because the lower court is not forced to ask the ECJ. They can freely decide. And so there is nothing wrong with the lower court's decision. That was a highly problematic decision, because here implicitly the BFH interpreted what the word can in Article 267, or whichever number it had at the time, what that word can means. And that is something which the BFH was not entitled to do so. So one could even criticize that. Good. Now, ladies and gentlemen, that should be enough for today. I hope you have now an idea of what a preliminary ruling is. You have now heard that states can be sued for infringement of the treaty. You have a general idea about what is interesting in a court decision, the arguments and the comments made by the court. And all that is something which you will need in the course of time in the later course of our lecture. So only one thing is left, that is last but not least, what you now still need is some experience with reading ECJ decisions. And so what you need now is just the internet site address of the European Court of Justice. That is curia, Latin for court, .eu, and you should, under all circumstances, get used to have a look at that internet site from time to time. Take a look at it and have a look on all decisions which, under the one or other aspect, are interesting for you. Because if you get an understanding of how the judges think in general, then you also get a feeling on how they will decide on tax matters. Very often it's a case if things like the freedom of establishment are interpreted in a non-tax surrounding, then naturally the understanding of freedom of establishment cannot change when the whole thing has to be applied to taxation. So what has been said, or what has been rejected as arguments constantly in other fields of law, will also be applicable to the tax area. And so it's really worth the time which you invest there if from time to time you have a look at new court decisions there. So that was rather a long one today. Thank you for listening. Hope I see you back again next time, and till then, recover well from today. Thanks for watching. See you again soon. Goodbye.